In the personal injury world, winning a he said, she said case is super hard, but not impossible. Anything's possible! But still pretty hard. You see, whenever you represent a plaintiff in a personal injury case, it's your job to help your client prove their case by preponderance of the evidence. Which means that in a he said, she said case, it's your client's job to overcome the competing story and to ultimately prove the case. And of course, despite knowing these difficulties, I took a he said, she said case.
This is he said, she said.
And this one was special because there were no witnesses, no video, and of course, no car damage. Basically, all I had was just two competing stories. Fortunately, I was able to take a super effective deposition of the defendant that showed the holes in her story. And as a result, I was able to get a settlement for my client that made him super happy. Victory! Maybe I should have saved that part for the end of the video. Welcome to Law Venture, a channel devoted to lawyers and future lawyers. My name's Jarrett Stone. I'm the owner of Stone Firm P LLC, and I'm here today to talk about depositions. In particular, with this video, I'm going to introduce to you a real live case example of he said, she said, where I was able to win the case with a stellar deposition. So whenever you have a he said, she said situation, you obviously have two stories. So let's introduce both stories by beginning with my client's versions of events. Like any other day, my client is bicycling to work. And in particular, in order to get to his job, he's bicycling on a sidewalk because the main street has a bunch of traffic. And as he's heading down this sidewalk, at some point he sees an intersection ahead of him. And as he's approaching this intersection, he takes a look and he sees that there's a stop sign and that a vehicle is stopped just past this stop sign. And then he looks ahead and sees a clear path between the sidewalk that he's on and the sidewalk at the other end of the intersection. My client enters the intersection, and as he's entering the intersection and finally in front of this vehicle, the vehicle ends up moving forward. And in moving forward, the vehicle hits my client. My client is then thrown from his bike onto the hood of the car. While still on the hood, my client looks inside of the vehicle and sees the defendant. Dazed and confused from the impact, my client then gets off of the hood, grabs his bicycle, and then hears a question being asked by the defendant. "Are you okay?" My client answers, "I don't know," and then goes behind the defendant's vehicle. A couple of the drivers behind the defendant end up coming out of their vehicles because they're basically stopped behind the stop sign as well. They ask my client how he's doing. My client says he thinks he's doing okay, and then as he's talking to them, also takes down the license plate number of the defendant. And after he gets the license plate number, he basically hops back on his bike and goes to work. Once the shock of it all wears off and as pain's starting to set in, my client realizes something's wrong, something's off. So he ends up calling the police and files an incident report using that license plate number. Now, on the other hand, we have the defendant's story, and her story goes a little like this.
I was headed home from work. I stopped at a stop sign. I was waiting for traffic to subside or for there an opening for me to get into traffic as I was trying to turn right to go southbound. A car proceeded to let me in. I started to go, the sensors on my car started to go off. So I stopped the car and I saw your client right there at the passenger side at the front wheel. And I asked him if he was okay. He said, "I guess." He proceeded to bike away. I looked around to see if I could find him. When I couldn't see him anymore, I drove away.
Okay, there's a lot going on in that. So we're going to unpack it a little bit. We're going to expand on it a little bit.
So boiled down, we have two very similar stories. We have bicycles, cars, an intersection, but we have two very different stories at the same time. With my client's story, we have an impact between him and the front of the defendant's vehicle, and that impact led to my client's injuries. But with the defendant, we have no perceivable impact, and all of this takes place at her front right passenger tire. So two very distinct stories which have different repercussions, because if there's no impact, then there are no injuries. And if there are no injuries, There's no personal injury case. So if you're in my situation as the personal injury lawyer representing the plaintiff, what do? You stress test the defendant's story. And the best way to do this is to take the defendant's deposition so that you can basically have a face-to-face and truly see if the defendant's story has any credibility. And when you don't have any witnesses, perceivable damage, or video footage, then you're really left with only one option: spotlighting objective facts. And with the defendant's story, she covers 3 topics that we can stress test with objective facts. First, location of the vehicle. Does her story make sense based on where she's saying the vehicle was located? Second, location of my client, the plaintiff. Same thing here. Does the story make sense based on where she's saying the plaintiff was located? Third, the car sensors. Does her version of events accurately depict how the car sensors actually work? A huge part of focusing on the defendant's story is stress testing the depth of the story. Anyone can come up with some surface level story, but depth is what separates a true incredible story from a bogus one. And in this case, the defendant's memory got a little fuzzy.
Possibly, but I don't recall. I don't know. I don't know for sure. I usually do, but I can't recall from that day. I don't know for sure.
For some weird reason, people think saying "I don't know" is a great defensive strategy whenever they're having their deposition taken. But in reality, if they're using "I don't know" as a crutch, that is a great way for the examining attorney to be able to tell a favorable story for their client. So after I stress test and tested the depth, which is a mouthful to say, to the location of the vehicle, to the location of my client, and to the car sensors, the defendant said, "Okay, you got me." Just kidding, that never happens. For those that have already seen the video that's sliding above involving the Scooby-Doo moment, you know that you're basically never really gonna have the aha, gotcha confession. But in this situation, with this particular case and this particular defendant, I kind of got the next best thing. As I was fleshing out the defendant's story and really stress testing it, I was beginning to see the story change. And as a result, towards the end of the deposition, I asked her, "Are you accepting any degree of fault in this case?" And this is how she responded.
I'm sure I had a small part. I don't know what the percentage would be.
Did you catch what just happened? Like we talked about earlier, and this is somehow me signifying earlier in the past. If there's no perceived contact between my client and the car, then there's no injury. And if there's no injury, what could she possibly be at fault for? Let's maybe flip the logic on its head by talking about it in the more positive sense, meaning that if the defendant is at fault to any degree, that means an injury occurred from an impact. Let's act like we're the defendant for a quick second. Let's say we're in our vehicle, and as we're approaching a stop sign, we come to a stop, and then we'll even say that we inch forward a little bit so we can get some extra visibility, looking left, looking right. And then out of nowhere, a crazy bicyclist comes up to a screeching stop and doesn't hit our car, turns around, sues us for injuries. Are we really going to accept any degree of liability, any degree of fault in that situation? No. So if we take this logic and combine it with the defendant changing her story throughout the deposition as the puzzle pieces were coming together, then I was able to have a successful deposition for my intended audience. But my audience was not the jury. It was not the judge. It was actually the defense lawyer. Plot twist. As discovery was developing and as I was maybe reaching out to the defense lawyer here and there, and especially during the deposition, I could tell the defense lawyer hadn't stress tested his own client's story. And as a result, I took it upon myself to do just that. I figured I'd help him out. And right on time, the defense lawyer, after the deposition, reached out to the insurance adjuster and recommended to get this case settled because the writing was on the wall. But here's the most important part of this video. This deposition that I've shown clips of was won because of the preparation, like a lot of preparation. From the day of signing up this client to the day of the actual deposition itself, a lot of evidence investigating, and strategizing went into the preparation of this particular deposition. And I want to share with you all of the important parts so you can take these gold nuggets and then go have your own successful deposition. Now, I can't share everything in this video because this video would be super overwhelming and it would take you forever to get through. Instead, I like to teach things in bite-sized chunks, which is why I have lessons and courses over at lawventure.com, and in particular, why I made this real case example into a course that you need to check out. And that takes me to the big question. Who lies about this? Guys, this is absolutely crazy what she's trying to do here. I've never had a deposition where somebody changes so much of their position. We're gonna have to overcome this. This is going to be an issue down the road. And the impact with the hood is what ended up causing his neck to whip back and forth, whip his hair back and forth. Jackpot. This is fantastic. This is really great. The first one is the clueless attorney. This is great because I can come off clueless very easily. Just ask my wife. But keep in mind, we do not see C here, which sounds like a pizza pitch here, and this is not sponsored by CC's Pizza. That one was exciting. That one made me pumped. Objectively speaking, that's going to obliterate my client's story. And we're gonna come knocking on y'all's door for y'all to pay under my client's coverage. I do have some concern about the defendant's story. This wins the case. In my mind, this is the most important question, and this is the best answer I could have gotten because it renders her story to be absolutely ridiculous. That probably gives me the most anxiety.
That wasn't the case, right?
I don't believe so.
And that right there is how you win a case with a deposition. We just got fantastic testimony. So for your convenience, what I'll do is slide a link so you can go check out this course. I also put a link in the description down below. And if you're new to LawVenture, then be sure to check out lawventure.com/courses so you can see the courses that are available for you and you can go get your fix. So with all this said, I look forward to seeing you in the course. And if you have any questions, comments, thoughts, concerns, or if you just want to say hi, you obviously know the drill at this point. Leave those in the comment section down below.